Hi. Welcome back. You came back. Some of you just came back. Yay. First of all, thank you for being here. Again, you don't have to be here, and whether you return next week or not, you make this work, or it's not going to work. You with me? I mean, I depend on you. So I mean that very much. Is my Twilight Zone episode is I walk in one first class and there's nobody here. I say now because I would still hold the class. Yeah. So this is lawyering 101. I mean, what the LSAT is measuring is, do you think like a lawyer? It's that bloody simple. But I think it helps when you explain, like, what does it mean? What does it mean, right? To think, what does that, I mean, slogans are called slogans for a reason. You with me? So next time you hear a slogan, could you ask the person for the underlying evidence in support or in derogation of the slogan, right? But slogans are meaningless to me, right? That's not lawyering. Lawyering is reasoning, right? And again, I can go back here to understand what the test tests. And again, I don't want to spend tons of time on this, but if I were to, and I will refer to this book, which is long since out of publication, was written by Thomas White. And would you agree with me that if you understood the mind of the person who created the test, you would have more information about the test? Yes. Talk to me, do you get it? Yes. Because if you're not going to be granular, nothing's going to work in here, right? You've got to slow down the speed up. Well, I myself cannot ride a bicycle. I taught both of my children how to ride bicycles. And we did start with training wheels. And so I'm training wheels. But this is a system of learning, and you've really, and it's right there. There's nothing fancy about this. Nobody needs Aristotle. Nobody has to take any class in formal logic. It's exempt. Can you think about how you think? Could you do that? Could you stop, right? And I want you to think about how you think. And we don't share brains. So we're not going to think the same way. But if you reason naturally the way an attorney reasons, then you're probably going to do pretty well on this test. So I just want to say a few things about, thank you. Has everybody signed in? No. Oh, losers, losers. Thank you. So I just want to say a few words about what the designer of the test said the test is doing. Does it make sense to know that before you take the test? Okay. So if I were, again, I could put this guy on the stand. Right? If I were to put this guy on the stand, I would be doing, if you're my jury, right? I'm putting the person on the stand to qualify the person as an expert. Would it be fair to say you will receive the testimony of an otherwise credible witness? The person has to be credible, right? But is it fair to say you would receive the testimony of an otherwise credible witness with somewhat greater receptivity if the person were qualified as an expert in their field? Yes. And were testifying about their field? Yes. Well, so you can be a lawyer. What was complicated about that? Does that mean the testimony cannot be challenged? No. Does it mean the witness testimony isn't flawed? No. But is it somewhat more likely the witness's testimony is reliable given that you find the witness to be credible? Where's Aristotle? Welcome to law, right? So this is the person, if I could bring this person physically here, I would bring this person in and say, I want you to tell them what you had in mind when you created the bloody exam. And this person would testify, and I'm reading from the book that the person authored, and his name is Thomas O. White. And Thomas O. White would testify to the following. I have worked with standardized testings and the LSAT for 25 years. During that time, I have administered, criticized, designed, interpreted, justified, promoted, studied, taught, thought, and testified about the LSAT. I have been responsible for the administration of more than 1.5 million administrations. Over half of the LSATs ever given at that time. And I have studied the results of over 2 million administrations. I have learned what there is to know about this generally unfamiliar test and the way test takers respond to it. And now I have an opportunity to share it with you. If that was the opening statement of a witness, and I'm trying to qualify the witness as an expert with respect to LSAT preparation, would you be more inclined to accept as valid what the witness was going to testify to?
Yes.
Well, do you understand this is how your world will proceed as a lawyer? Did I give you any slogan?
No.
Oh, go figure. No slogan. Evidence. So now we qualify the person as expert and say, well, okay, so what insight can this person give us, right? Here's what Thomas O. White writes. The LSAT tests your skill at being able, quote unquote, to think like a lawyer. Stop for a second. Would you now agree it is somewhat more likely that the purpose of this test is to measure whether or not you think like a lawyer?
Yes.
Talk to me.
Yes.
And would you agree we now need to understand what that means?
Yes.
Oh, okay. He goes on. Maybe he's going to give us some insight. Would you rather have that insight from Thomas O. White or from me? Who would you rather have it from? Thomas O. White. You with me? With all due respect, fuck me. You with me? You got the expert in court, right? That's who you want to hear from. And here's what he says. Following, it's testing your skill at being able to think like a lawyer, and those are in quotes. That is, reasoning in the principal ways law schools and the legal system require. So if we examine that, reasoning in the principal ways law schools and the legal system require, what is the principal way that law schools require you reason?
Like a lawyer.
But what is the actual, if you will, there's a pedagogical tool, there's a method you're going to be used, that you're going to be taught in law school. Right there. Right there. So when Thomas White refers to, you need to think like a lawyer, that is, you need to reason in the principal ways law schools and the legal system require. Well, if he's referring to issue, rule, analysis, conclusion, would you not infer, you see, these are facts we just got, right? The facts are the testimony of the witness, yes? Talk to me. Come on, you want to be lawyers, right? Okay. So now we have the facts from the witness. Would you infer from that fact that what Thomas White is referring to is IRAC?
Yes.
That the principal way is IRAC, yes? Would you further infer from that fact that if you apply IRAC to the LSAT, Thomas White would probably encourage you to do that? Would you further agree that if you became fluent in IRAC now, and it's how you're going to have to learn later, you would be in an advantageous position, a more advantageous position then than you are now? Talk to me. And then you're competing with people who did get into law school and have no clue about this connection. And wouldn't that place you at a competitive advantage to them? Talk to me.
Yes.
So you get, this is not polemics, this is not rhetoric, this is not politics, it's not philosophy, it's not engineering, it's reasoning. Can you do this? Well, then you can be a lawyer. Again, if God has other plans, that's one thing, right? But short of that, you can do this, you can be a lawyer. I don't care what your GPA is, I don't care what school you went to. You want this, then work your ass off for it. This way of thinking, Thomas O. White continues, this way of thinking is generally unfamiliar to people who are considering legal education. Let's stop on that. Would it be fair to say that to most of you, This way of thinking is presently unfamiliar.
Yes.
Talk to me. Anybody want to engage with me on an IRAC analysis? Just show it off. Vicki could do it. But do you get, it is unfamiliar, isn't it? Does that mean it's hard? No. It's unfamiliar. So this way of thinking is generally unfamiliar to people who are considering a legal education, and the LSAT attempts to measure their aptitude for it. So what is the LSAT attempting to measure?
How low you think record.
Correct. In other words, could it be, and I assure you it is, could it be that some of us are sitting here and we are intuitively reason this way?
Yes.
Could it be that some of us sit here and we're going to have to learn how to reason this way? And could it be that some of us are sitting here and we're not going to be able to reason this way? You bet. You bet. But at least now, you know what you got to do. Yes? So I could go on, and I'll refer to White as we go through the course. But my central premise here to put forth, right, is that it's all about IRAC, getting fluency in this, and then going back to the analogy I drew earlier on, right? There is no difference in the fundamental challenge of an of an aeronautical engineer learning the discipline of aeronautical engineering, right? There is no difference between that and a lawyer learning how to do lawyering. You with me? And insofar that your personal life experiences interfere with that because you want to do whatever you want to do and screw the law that gets in your way, well, this is going to be a very tough transition if you ever make it at all. You with me? It's a piece of business. Take the piece of business, get it down, learn how to drive the car before you decide where you want to take the car. But you're going to learn how to drive the car. It doesn't matter if you're conservative or not conservative, progressive or not progressive, whatever that means. You with me? It doesn't matter. Okay. So we're going to build on this. We're going to build on this concept of learning what IRAC is. And we're going to start here, which is, I'm saying, they're really just testing whether or not you can solve an issue that they're presenting to you a bunch of hypothetical situations, right? But if you naturally reason this way, you're going to solve these hypothetical situations the way the person who created the hypothetical situation designed them to be solved. It's a psychometric test. You with me? Psychometric. It's not academic. And White goes into this. He doesn't use the word psychometric. But he goes into, if you're trying to complete this test, you're either a genius or a fool. And it's far more likely you're the latter. And that takes some exploration, that takes some humility, that takes some thought. But what it results in is a plan. Here, Braulio, what he was talking about, he wanted this number in this section, this number in this section, this number in this section. Don't you think there was some forethought that went into that? Talk to me, come on.
Yes.
Come on, right? That's planning. What lawyer is going to be successful that doesn't plan? None. And yet there are people in life, right? I know a bunch of them, I'm sure you do, right? Who couldn't plan their way out of a paper bag. And they could be wonderfully successful in whatever they do, right? But you're not going to be a lawyer. So what I'm going to do is now start to tear this apart, is to say, this is how, I'll just do this briefly, and then I want Vicki to come up and speak. Get what this is about. That's what an argument is. There's nothing more and nothing less. So you start with facts that are established, right? Now we need to explore this. What does that mean? What does it mean that facts that are established? Well, in law, it means facts that are stipulated to. Could we stipulate to something that was wrong? Could we agree, could you and I agree that last week there was no Wednesday? Why not? Well, respectfully, if one party, when you say no, is it fair to say it is not possible in the real world that there was no Wednesday last week? Is that fair to say?
Yes. Yes.
Right? But then the assumption is we are restricted or constricted by external reality. So, in a courtroom, all jurors will be instructed that the only information they are to consider is the information that was presented in that courtroom. So you will not go visit a crime scene. And if the parties were to stipulate to a description of the crime scene that was incorrect, well, you know what? That's what malpractice is for. But if the parties theoretically wanted to go into court and say, Your Honor, both counsels agreed it was no Wednesday last week. And the judge would look at us like we had two heads. And the judge would say, you guys know there was a Wednesday last week. And we'd say, yeah, we know that, but that's not what we're saying. We want it presented to the jurors for the purposes of settling this matter that there was no Wednesday last week. And the judge would say, okay, I'll instruct the jurors to consider as a fact there was no Wednesday last week. So from the juror's perspective, what did last week lack?
Wednesday.
Bingo. That's our world. You with me? That's all over the bloody LSAT. If you're reading this test and the very first sentence in logical reasoning is, every planet you'll never see is purple, what do you now know is an established fact? That's the first transition. You with me? We create our own universe. We do definitions that we create. My definitions don't come out of Webster's dictionary. Right? Every legal text has its own definitions, and they oftentimes conflict. So, an established fact in the real world is a matter not in dispute. It's both parties are stipulating to it. Whether it's accurate or not is irrelevant. Both parties stipulated to it. On the LSAT, established fact is everything you read. That's the way they present it. So everything you read, you are not to dispute. You with me? No matter how viscerally you disagree with it, let me break the news to you now. Nobody cares what you think. You with me? We don't give a rat's ass what you think. What does the law say? I don't care what you think. You with me? Because if you allow your thoughts to change the law, it's no longer the law. So one is saying, well, when I assert something is established, I have to prove it's established. You with me? From established facts, and only from established facts, can you get inferred facts. So, do you have a popular? Now, we're going to pretend I didn't just look over there, right? We're going to pretend I didn't just look over there and whisper, call me, right? All right, and now we're going to say the difference between a fact and an inferred fact, and it's essential you get this. Make sure I didn't turn it off. Of course I have. I don't know. Does everybody agree it's a fact that this phone is making a noise?
Yes.
Does everybody agree it's a fact that there appears to be a name at the top?
Yes.
Okay. And now I'm going to do this. Hi, Vicki.
Hello.
Does everybody agree I just inferred by saying hi, Vicki?
Yes.
Then you can all be lawyers. Break it down. A fact because you've all stipulated and agreed that there was a sound, yes? Mm-hmm. No matter what your politics, no matter what your religion, no matter what your socioeconomic status, you all agreed we heard a sound, did you not?
Yes.
And the same is true of the name, although you could not see it because you're too far away, yes? Mm-hmm. And if I further say the name that appeared was Vicki Gormanley, and I then were able to testify as Thomas White just testified, right? If I were able to testify that that is the name of the woman who for some unfathomable reason married me, you would credit my testimony, I suspect, yes? would you agree from those three facts, the sound, the name, which is Vicky Gormanley, not John Doe or not John Smith, Vicky Gormanley, with the correct spelling of Vicky, would you agree, and then my testimony of I recognize the name as the name of my wife, would you agree it is a reasonable inference on my part to anticipate or expect Vicky will be on the phone? Talk to me.
Yes.
Reasonable, yes, talk to me.
Yes.
Because this is all about nuance. Does everybody further agree it didn't have to be Vicky on the phone?
Yes.
Yes.
Could it have been Vicky left the phone down and it was one of our daughters? Could that have been the case? Talk to me.
Yes.
You gotta slow down and then you're gonna get this. With me? So an inference is a fact not woven into the fabric of the established fact, but which flows from the fabric of those facts. Didn't we just extend the argument? When I said, hi, Vicky, didn't I give you a conclusion? Isn't my conclusion Vicky's on the other end of that phone? Talk to me.
Yeah.
In order for that the conclusion to be valid, don't I have to have made assumptions? Oh. And if my conclusion is wrong and it's not Vicky, didn't I engage in a flawed argument? And I gave you my conclusion, it's Vicky, it's right there, right? Talk to me. And could I gather further evidence before I drew that conclusion?
Yes.
Could I require that the person on the other end speak to me? Could I require that? And wouldn't that strengthen the argument? But I didn't do that because I was rash and I wanted to talk to my wife. Couldn't we weaken the argument by also allowing the voice to come in? Because you see, I haven't heard the voice, have I?
No, right.
Son of a bitch. I haven't heard the voice. So I have an incomplete argument, don't I? Because I haven't heard the voice. So if I get that and it's not Vicky's voice, haven't I weakened the argument? If I get that and I then testify that's the voice of my wife, haven't I strengthened the argument?
Yes.
And the principle here would be how much evidence is required upon which you decide you can draw safely a conclusion. What is the quantum of evidence required of all cases before you draw a conclusion? And conclusions is so much, so you guys talk to me. You get this is how you're going to reason. How much politics is involved in that?
Zero.
How much does it matter whether you voted for Trump or Clinton is involved in that?
Zero.
None. You with me? Lose it. And of course, to complete this, so again, if I'm back in the office, right, that's how I'm going to attack a case. What facts did I say? Because I got to go in front of juries, right? Well, I don't now, right, but I have. Right? And I'm saying, well, what can I present to jurors that they'll say, yeah, that's right. There was Tuesday last week. Right. What facts am I inferring that you guys would accept? Didn't you all agree it was likely Vicky would be on that phone? Talk to me.
Yes.
So if I argue in summation it was likely Vicky would be on the phone, the jurors would be in agreement with me, yes?
Yes.
So they are agreeing with the inference. If I argue to you it must be Vicky on the phone, you would not be inclined to agree, would you? Talk to me. You would not be inclined to agree that it must be Vicky on the phone.
No.
And if I didn't point that out to you, don't you think defense counsel would?
Yeah.
Inquiry. So, that's what we do. No matter what area of law you're practicing, you with me? You're aware of facts, and you get that these are going to be challenged, right? These are going to be challenged by the other side. I'm claiming they're established. I'm claiming that white powder is cocaine. What do you think defense attorney's going to do? Challenge it, right? But I'm putting the expert up there, and the expert's going to say it's cocaine. Does that mean it's cocaine? No. So it's persuasive, it's not conclusive, right? Persuasive, not conclusive. That's what you're looking for in 99% of your arguments. Persuasion, not certainty. And you see how all this works. That every time you infer, you're at risk of error. You with me? Because it's not woven into the fabric of the established facts. You guys get that? Talk to me.
Yeah.
So you need to be aware when you're inferring, because you're at risk of error. And the ever popular, you don't know what you don't know. So how do you act as an attorney by having a large, would it be fair to say with respect to the virus that's out there, would it be fair to say there's a lot we don't know about this virus? Talk to me.
Right.
And yet, I suspect you'll find people who are figuring out what to do about it. Do you get it's hard to figure out what to do about it when you don't know what it is? Talk to me. So that actually, I'm sure, is what's going on in the scientific community. They're trying to get this from here to here to here. But you can deal with it. So do you get now, you can no longer be an ideologue. You can be an ideologue when you're not practicing law. By all means, please do so, if that's what floats your boat. But do you get, when you have strong views, it can cut down the investigative process. It can just shut this down because you don't want to know what you don't know because it might be contrary to what you want to believe.
Yeah.
Yeah, we'll get over it. And of course, imagine you couldn't just characterize people who disagree with you as deniers. Imagine you couldn't do that. Imagine the deniers had a voice. Would you want to hear it if you would characterize them as deniers? Would you want to hear it? If you're characterizing somebody as a denier, might you shut down on what they have to say? Talk to me.
Absolutely.
A little bit. Well, then why are you characterizing them as deniers? Why aren't you characterizing them by a term that might be less inflictive? Deniers just sounds like, boy, you got it. So, I think I would, again, you have to leave the world, you can go right back to it, right? As soon as you're not doing a legal matter, you just go back, call everybody a denier who disagrees with you. But when you're in this endeavor, it's the relentless pursuit of an outcome that is persuasive. And you're not going to be persuasive by denying the other side a voice. Yes? So do you still want to be lawyers? Oh, risky. Well, that's what I'm going to pursue. Does it sound like this is something you can do? Talk to me. Come on.
Yes.
Right. And if we were to actually use examples of this, which we're going to do, and you were actually saying, son of a bitch, when I do this and I'm given a problem, I actually can see the conclusion the writer was going to draw before I ever look at an answer choice. How cool would that be? But that's what the writer's doing. If the writer is writing using IRAC, the writer has a process that simply occurred earlier in time than the process that you're using, right? So if you reason the way the writer reasoned when the writer wrote it, don't you get, on a bunch of these questions, you're going to have the answer before you ever look at the answer. Talk to me.
Yes.
Okay. Any questions on that? This is so exciting. What am I supposed to say?